The new bar exam puts DEI over competence. NextGen seeks to eliminate any aspects of our exams that could contribute to performance disparities by testing fewer areas of law and probing each subject less deeply. The bar exam is about to get a nationwide overhaul. The National Conference of Bar Examiners, or NCBE, which creates and administers the Uniform Bar Exam, plans to roll out a revamped version of the bar exam, which it calls the NextGen exam, in 2026. After attending the NCBE's annual meeting this month, I have serious concerns about how this test will affect law students, law schools, and the legal profession. The proposed NextGen exam will be shorter than the current 2-day evaluation, test fewer areas of law, and probe each subject less deeply. Certain topics won't be tested at all. The exam will also feature new client interaction exercises, though it's unclear what this feature will look like and how the NCBE will ensure it is graded objectively. Some of these changes may prove salutary. Working with clients, for example, is an essential feature of any law practice. But the new exam also seems far less rigorous and could hamper the ability of states to determine who should be admitted to practice law. The results could be ruinous. States can't maintain functional court systems unless clients and judges can trust the basic competency and integrity of attorneys admitted to the bar. The proposed exam will also eliminate family law and trusts and estates as tested subjects. Tens of millions of Americans live in rural areas and small towns, where legal needs typically revolve around family law, marriage, divorce, custody and adoption, and probate matters, estate administration, guardianships and conservatorship. In many rural areas, residents' access to justice depends on the ability of only a handful of practicing attorneys. These residents need to know that new lawyers have the foundational knowledge to serve their needs or at least the threshold understanding necessary to refer them elsewhere. If these areas of legal practice are eliminated from the exam, it will be difficult to replenish the requisite knowledge in our lawyer ranks. But perhaps the biggest concern is the NCBE's use of the NextGen exam to advance its diversity, fairness, and inclusion agenda. Two of the organization's stated aims are to work toward greater equity by eliminate any aspects of our exams that could contribute to performance disparities and to promote greater diversity and inclusion in the legal profession. The NCBE reinforces this message by touting its organization-wide efforts to ensure that diversity, fairness, and inclusion pervade its test products and services. What does all this mean, and how does it have any relation to the law? Based on the diversity workshop at the NCBE conference, it means putting considerable emphasis on examinees' race, sex, gender identity, nationality, and other identity-based characteristics. The idea seems to be that any differences in group outcomes must be eliminated, even if the only way to achieve this goal is to water down the test. On top of all that, an American Civil Liberties Union representative provided conference attendees with a lecture on criminal justice reform in which he argued that states should minimize or overlook would-be lawyers' convictions for various criminal offenses in deciding whether to admit them to the bar. None of this is encouraging. It shouldn't matter who you are or where you come from. If you can demonstrate minimal competency on the bar exam and meet a state's character and fitness requirements, you should be allowed to practice law. If you can't, you shouldn't be given a license to handle the legal affairs of others. The bar exam should test the law straight, without respect to ideology and on a race and sex-blind basis. If NextGen comes online as scheduled in 2026, students entering law school this fall will be the first crop of graduates to take the new exam. This means that, in short order, law schools would have to begin reconfiguring their curricula to focus on subjects tested by the new evaluation. Which is to say the NextGen exam is already here and will soon begin to eclipse the current test, perhaps well before states understand what is on the exam and whether it makes sense to adopt it. State courts and licensing authorities shouldn't be pressured or hurried into making such an important decision. It is imperative that the NCBE disclose as much detail as possible about the content, scope and scoring of NextGen before law students show up this fall for the next academic year. States, for their part, should push for the option to retain the current exam for at least the next 5 to 10 years until they can properly assess the effectiveness of the new exam. State courts and bar associations would also do well to insist that the NCBE commit in writing that the new exam will be ideologically neutral and blind to race and sex. Meantime, a wider range of people, judges, lawyers, law school deans, scholars, public interest groups, businesspeople, law students and members of the public, should take a look at the exam and provide the NCBE and their state supreme courts with feedback on whether it should be adopted. The future of the legal profession hinges on that determination. The new bar exam puts DEI over competence. NextGen seeks to eliminate any aspects of our exams that could contribute to performance disparities by testing fewer areas of law and probing each subject less deeply. The bar exam is about to get a nationwide overhaul. The National Conference of Bar Examiners, or NCBE, which creates and administers the Uniform Bar Exam, plans to roll out a revamped version of the bar. The Clarence Thomas stories that PBS refused to tell. I gave an interview about the Supreme Court justice that ended up on the cutting room floor. Hey race, what the network didn't air. A popular tactic of American politics, especially on the left, is to attack the character of those with whom you don't agree. This was evident with the recent show, Clarence and Ginny Thomas, Politics, Power and the Supreme Court, which PBS aired on May 9. A PBS producer emailed me last January about a planned documentary on the life and legacy of Justice Thomas, who used to work for me. The producer wrote that she wanted to speak to those closest to him to present a nuanced portrait, and she would, therefore, like to request an interview. I agreed to an interview that lasted an hour and a half. That was my mistake. The resulting show was far from nuanced, and it wasn't really a documentary. It was a 2-hour hit job on the character of Clarence Thomas. I am indeed close to the justice. He worked for me twice, first as an assistant Missouri Attorney General, then later as a legislative assistant in my Senate office. In the nearly 50 years I have known him, I have never commented publicly on his judicial philosophy or discussed with him a case before the court. My relationship with Justice Thomas can be summed up succinctly: I am his friend. Trusting that PBS wanted personal memories that illustrated the character of my friend, I shared 3 stories that go to the heart of the man. Maybe because these stories contradicted the narrative PBS chose to present, it didn't run any of them. The only excerpts from my interview it showed were biographical filler. To tell the real story of the person I know, I now relate what I told my interviewer and what PBS declined to show. The first story is from when I was Missouri Attorney General and Clarence Thomas was in his 20s. Another young lawyer in our office, Dick Wheeler, was a quadriplegic. Dick could operate a motorized wheelchair and used a stick between his teeth to turn the pages of law books and use a phone. He relied on friends to care for his basic daily needs. Clarence helped care for Dick